All right. Tonight, Belinda and I will be presenting, and Belinda has been our supervising attorney for over 10 years, and she's been with the firm for many, many years as well, and she is amazing to work with. So basically, we're going to discuss this evening who can receive assistance under the Trial Benefit Services, what type of actions are covered under the Trial Defense Services, which means civil, criminal, those kinds of things when we talk about what type of actions. What type of assistance is provided under the Trial Defense Service, 10 common issues that impact trial defense coverage, a review of various scenarios involving trial defense. So who can receive assistance under this Trial Defense Service? Go ahead, Belinda.
The trial defense services are only available to the member and the member's spouse.
Sorry, I have a freezing internet, sorry.
That's okay. The dependents on the legal plan are not able to receive trial defense services. They can, however, receive assistance under the preferred member discount. So if there is a dependent who is sued in a civil action as a defendant, they will be offered the preferred member discount as opposed to the trial defense services.
Types of actions covered under the Trial Defense Services. Go ahead, Belinda.
For trial defense services to apply, the lawsuit must be an action where the member or the member's spouse is the defendant in a covered civil action filed in a state or federal district court.
Assistance provided under the Trial Defense Services.
There are two types of coverage that's provided under the trial defense services. The first is pretrial time. And just to summarize what this slide says, these are things such as responsive pleadings, responding to the complaint. If there's any depositions that need to be taken prior to trial, any type of work letters back and forth with the other side, trying to set up agreements or settlement negotiations, right up to the doorstep of trial. So that's what's considered pretrial time.
Belinda, how do members calculate their pretrial time?
That is a good question. It is listed on their plan. And so that is something that whenever the member calls in and they qualify, a review's been done and they qualify for the trial defense services benefits, the first thing that Noemi does is she goes to the plan and she reads the section, because there are various plans. We're doing the most current legal family plan today, but there are various older plans that have different calculations that are made regarding pretrial versus trial time and how much is available. So we look at that, we calculate that, and then we make sure that the referral attorney and the member are aware of how many hours are available at that time. Okay.
Assistance provided under the Trial Defense Services.
And this is the other half. This is the trial time. This is the time rendered in defense of the lawsuit from the date of and including jury selection, opening statements, up to the date of verdict or bench decision. It's limited up to 8 hours per trial day, may include attorney time both in and out of the courtroom. So once you're in the courtroom and the jury's been selected and you're ready to go, that's when the trial time kicks in.
Important notes about the use of trial defense services.
The number of hours are available to use on all covered lawsuits filed during the membership year. And this is important. If more than one covered lawsuit is filed against a member or the member's spouse in a given year, the hours remaining at the conclusion of the first lawsuit may be used for any following lawsuits. So there is theoretically the possibility, we have not encountered this very often in the 20 years I've been here, but if there are two magistrate actions filed against a member in a given year, and they didn't use all their hours in the first one, the remaining hours in that year are still available to them for the second lawsuit. Okay. In no event will the number of available hours exceed the annual maximum number of hours. So once that limit's hit, then it converts into a preferred member discount situation.
And they would get their hours back the following year.
Correct. Hours not used during the membership year expire at the end of the membership year. So those hours, there's no rollover of hours. And the member must continue his or her membership while any covered action is pending to receive services. That means that you don't join LegalShield, get your defense, and then, you know, in the middle of the action, drop your LegalShield coverage. Once you terminate LegalShield services, these defense benefits are no longer available.
10 most common issues impacting trial defense coverage. Effective date of membership.
For trial defense services to apply, the facts giving rise to the cause of action, and this is always an issue. We encounter this a lot, and this is probably the most common reason that trial defense services are declined. It has to take place during the member's active membership. So if the lawsuit involves events that take place prior to the effective date of membership, there will not be trial defense services available. So if a member is told that, or they think that just by signing up, because they've been sued in court, they're going to get trial defense services, that is not the case. If the lawsuit involves an auto accident or an issue with a neighbor or anything that gave rise to the action that was filed, if it all happened prior to the membership, there's not going to be trial defense benefits. We'll still offer a preferred member discount, but the trial defense services will not be available.
Is it a civil action?
This is the next thing that arises, is it has to be a civil action filed in the state or federal court. It can't be a criminal action. It can't be a domestic action, divorce, separation, annulment. These are all not considered non-civil actions. They're specifically listed in the membership agreement with LegalShield as not being covered and excluded from trial defense services. So the member, it has to be a civil filing in a state or federal court, and the member has to be the named defendant.
Whether the complaint has been filed and served.
Yes, a request for a referral or for coverage of trial defense services, we can't review it or make a determination regarding whether those benefits apply until the member is actually served with the complaint. So if they think that a lawsuit is coming, or they've received notice that a lawsuit is coming, but the lawsuit has not yet been filed, we cannot execute this portion of the plan until that service has actually taken place.
So the member has to actually accept service from the sheriff in order for us to make that determination if the coverage is available.
Correct. Or be served certified mail. I think some magistrates serve by certified mail. So yes, they have to actually be in possession and served with the complaint.
Status of case.
Yes, these are only available, the benefits are only available for defense of the initial lawsuit. These services aren't available for appeals, post-judgment relief, matters that are already in the midst of litigation. In addition, counterclaims are not covered. Sometimes a member will file a legal action and then there'll be a counterclaim made. Those are not covered under the trial defense services. And again, this is specifically listed in the plan as not being covered.
Deadlines.
For a matter to be considered for trial defense services, we need to have at least 10 business days between the time the member calls and when a responsive pleading is taking place. So this is important and something that members should always be made aware of, and we always tell them, as soon as you're served with something, you need to let us know. Don't sit on it. Don't wait until the day before the hearing. Don't wait until day 5 of a 10-day notice for default judgment to give us a call and ask for these services. We need the opportunity to review the action, determine whether or not trial defense services apply, and then we have to find an attorney. So we need those 10 business days.
Yeah, in these situations, time is of the essence. So as soon as they're served, starts the clock, and typically you get 20 days to respond to a pleading. So get it to us ASAP.
Yeah, and the attorney, especially in a civil action filed at the county level or at federal level, filing an answer to a complaint is not a simple matter. The attorney is going to be putting their name on that lawsuit, so they are going to want to make sure that anything they put for a defense is true, accurate, and that the evidence that they have supports any of the allegations that they place in that defense. So.
There must be a meritorious defense to the civil action.
Yes, in order to receive trial defense services, there has to be a meritorious defense. Whether or not a defense is meritorious is determined by, in our firm, it's myself and Mike Fiffick. We review it. We go through all the different pluses and minuses and determine whether or not there's a meritorious defense. So, for example, if someone is being sued on a credit card and they owe the money and they want a defense, well, they owe the money. So that's not a meritorious defense. So, if there's no meritorious defense to the action, then there won't be trial defense services. Now, same situation if you're served, if the member's served with a complaint for not paying a credit card and they have proof that it was paid off and they have the paperwork or they have some sort of evidence, bank account, whatever, showing that the debt was paid, that's a meritorious defense. So in that case, trial defense services would be extended to the member.
Business-related matters.
Any defense of a lawsuit that involves the member's business or member's business interests are not covered under the legal plan's trial defense services. So most common types of cases that we encounter that are business related are landlord-tenant situations where the member's a landlord, and they are sued, under the legal plan. That's an income producing venture. It's considered to be a business matter, and those are not covered under the trial defense services.
The ability to pay a retainer.
So an important thing to know, trial defense services do not include court costs or pretrial trial hours beyond what is set forth in the legal plan. So most lawsuits filed at the county level, there will generally be several pretrial attorney hours required beyond what's provided for in the plan. So even when trial defense services are approved, the member should expect to pay some sort of retainer. And again, usually that is something that Mike and I also discuss before we, when we're agreeing to extend trial defense services, we make sure that, in magistrate cases, generally the answer is going to be no, there's probably not going to be a retainer in a small level magistrate case. But once you get at the county level or federal level, those hours are going to get eaten up, especially at the pretrial stages. We talk about a brief estimate that we can provide to the member. This is going to approximately cost X amount of dollars in a retainer based upon our review, so that the attorney, when they go back to explain to the member, yes, there's coverage, but there's also going to be some additional funds that will likely be required as a retainer, so that the member is aware of that up front.
Continuation in LegalShield membership.
And like I previously stated back at the beginning, the member has to continue their membership while any covered action is pending in order to continue receiving the trial defense services. So they have to stay a member for the duration of the lawsuit.
And we do check, and if this is referred to our private side or to another attorney taking the matter, they do ask us to check. So we do check to make sure the member continues their membership. Status of the member in the action.
Yes, there are some specific exclusions, regarding status, and this again is set forth expressly in the member's plan. Trial defense services are not available where the member's acting on behalf of or representing another party. So examples of this would be an executor or administrator of an estate, a guardian, or a trustee.
Now we're going to talk about some scenarios involving the trial defense services, just to give you an idea of how they play into your members' everyday lives. Scenario number 1. Ashlyn, the named member, has contacted her provider firm for assistance. Her husband, Miguel, has been sued by a contractor for failing to pay for the home improvement performed on the family home. The contractor never completed the job, and was paid for the work that he did perform. Would this matter be covered under the trial defense services?
And the answer here is yes. The trial defense services are available both to the named member and the named member's spouse, in this case, Miguel. In this instance, since he is Ashley's spouse and there's a clear defense to the action, they paid for the services that were performed and did not pay for what was not performed. So trial defense services will be made available to Miguel in this situation.
Scenario number 2. Clark has been a LegalShield member for 15 years. Way to go, Clark. He has been sued by a company called Collectors, Inc. over a credit card debt. Clark paid off several years ago. Clark immediately calls his provider firm for assistance. Can Clark receive a referral under the trial defense services?
And the answer is absolutely yes. This was one of my prior examples, actually. Clark has clear defenses to this action. The matter arose during his membership. He paid off the debt, so we would extend trial defense services to Clark in this situation.
Scenario number 3. Tara properly vacated an apartment she has been leasing for 3 years. She is now being sued by her former landlord for causing damage to the property, and a landlord is also refusing to return her security deposit. Tara disputes this, causing any damages to the property, and has pictures to prove that there was no damages caused. Can Tara receive a referral under the trial defense services?
And the answer here is yes, in order to defend the lawsuit that her former landlord filed against her. However, if she wants to countersue the landlord for the return of her security deposit, that portion of the action is considered a counterclaim, so that would be offered to her under the preferred member discount. And the attorney would discuss this with her, even if she doesn't bring it up, wanting to countersue, because certainly we want to make sure that the members are aware of all their options. Yes, she wants to defend the action, but hey, she also has this right to this counterclaim or to countersue the landlord, and the attorney would certainly discuss that with her.
Scenario number 4. Mark signed up with LegalShield yesterday. He was sued 2 weeks ago by his neighbor over a property line dispute. He contacts his provider firm as soon as he can, seeking representation under the trial defense services. Can he get coverage?
The answer here is no. His matter won't be covered, and I give the exclusion information here just so everybody is aware of it. Those acts that occur prior to the effective date, so this is considered pre-existing. This all happened prior to his membership, so we would not be able to extend trial defense coverages here, but we would still offer him a preferred member discount.
Scenario number 5. Maria's son Juan has been sued. He is a dependent under Maria's legal plan. He calls in to request referral under his trial defense. Can Juan receive a referral under his trial defense services?
And the answer here would be no. Oh my goodness.
You have an echo now, Belinda.
Yeah, somebody is not muted. Okay, only the named member or the named member's spouse may qualify for trial defense services. So under exclusion 4, other dependents such as children are not covered. He will still qualify for a preferred member discount. You see that theme, we can't give you the trial defense services, we will always offer you that discounted referral, because that is an important part of the membership.
April is sued by her former friend Lisa. April successfully represents herself at the hearing before her local magistrates. However, Lisa has now appealed and filed a complaint at the local county court of common pleas. April contacts her provider firm for assistance. Can April get coverage?
In this situation, no. She would have qualified for trial defense services at the magistrate level. However, because this matter is now on appeal, it will no longer qualify. Exclusion 9 basically clarifies and makes it clear that there's not trial defense services available for appeals.
Jackson has just been served with a lawsuit filed against him in federal court for backing out of a contract to purchase a luxurious yacht in Florida. The seller has failed to disclose several problems with the yacht, and Jackson had properly terminated the contract. He contacts his provider firm for assistance. Will Jackson receive benefits?
And the answer is yes. Trial defense services are available, to a defendant who has a meritorious defense, whether that's filed in state or federal court. So this is a civil action filed in federal court. He has a good defense, so he can receive trial defense services.
Judy was shopping at her local shopping center when she was stopped by, oops, sorry. Let me see if I can get back to that. Hold on. Oh, I lost that one, Belinda, sorry.
That's okay. I'll summarize. Judy was stopped and charged with shoplifting, I believe, in that scenario, and she contacted her provider firm wanting to know if she would qualify for trial defense services. She's actually defending criminal charges here, not a civil pleading filed against her, and that's the first exclusion. They're not available for the defense of any criminal charges. However, as kind of repeating myself over and over again here, she'll still be offered that preferred member discount to defend the charges.
Dave owns a house that he inherited from his grandmother, which he has converted into 2 rental units. A former tenant has sued David for the return of his security deposit. David would like to have an attorney represent him at the upcoming hearing before the local magistrate. Can David receive coverage under this?
And the answer here would be no. It's a rental property now, so it's considered to be business related. The trial defense services are not available for any income producing property or venture. Also, a preferred member discount would not be available here either because the general exclusions of the plan preclude coverage for any business matters, unless he has the home business supplement, the preferred member discount would not be available. But we would still offer him a courtesy referral in this situation.
Suzanne was involved in a car accident where she was struck from behind and pushed into another vehicle. The driver she was pushed into has now filed a lawsuit naming Susan as one of the defendants. Susan's insurance company has told her that she is not at fault. Susan calls her provider firm upon being served with the lawsuit for assistance. Can Susan receive the trial defense services?
And the answer here is no. There's actually an exclusion in the general exclusions of the legal plan, which excludes any matters which are covered by an insurance policy. In this situation, Suzanne's automobile insurance carrier would be the first obligor defending this action. We would obviously assist her in, contacting her insurance company if necessary, and ensuring that they would provide indemnification, which is basically coverage for the lawsuit, and hire an attorney at no cost to her. That's generally how these situations are handled. Same thing in a homeowner's situation. If someone falls in a hole in your yard, and they file a lawsuit against you, your homeowner's insurance is the first obligor. So, we don't leave the members high and dry. We try to explain who is supposed to cover them, how and when, and then help them get in touch with those insurance carriers if need be.
Juliet's ex-husband has filed for custody of their 2 children. She has contacted her provider firm for assistance and asked for a referral under her trial defense services. Can Juliet receive trial defense benefits in this situation?
And the answer here would be no, because again, this is one of those exclusions that I mentioned earlier. The trial defense services aren't available for matters relating to divorce, separation, child custody, other domestic related issues. She would, however, be eligible for a preferred member discount referral.
Tiger hits a parked vehicle, and the police investigation determines that he was under the influence of prescription medication. The owner of the parked vehicle sues Tiger for the cost of the repairs. Tiger has contacted his provider firm to obtain representation under the trial defense services. Can he get benefits?
The answer here would be no. There is exclusion, much like with the criminal situation. Exclusion 2 then goes on to explain any lawsuit that involves the use of alcohol, drugs, substance abuse, those types of things, whether they're prescribed or not, hit and run charges, or leaving the scene of an accident. So since he was under the influence of prescription medication, trial defense services would not be available. However, he would still be eligible for that preferred member discount.
Philip received a trial defense service referral in January for a lawsuit that was filed against him by his neighbor, and he won at the district magistrate. It is now June, and he has been served with another lawsuit by a former friend over the return of a lawnmower that was given to Philip as a gift. Can Philip receive a referral for the trial defense services in the second action, even though he's already used his trial defense services this year?
And the answer here is absolutely yes. So long as he's not used all of the time allotted to him for his trial defense services, he can continue to use those under his plan for any subsequent lawsuits, including this one. So as I had cited in the language before, if more than one covered lawsuit is filed or against the member or the member's spouse in a given year, any remaining hours can be used for a subsequent lawsuit.
Sid has received a notice that his medical license may be suspended and he must appear before the state licensing board for administrative hearing. He contacts his provider firm and requests a referral under the trial defense services. Can everyone please mute themselves? Unfortunately, I can't mute everyone and allow myself and Belinda to speak. So if everybody can please mute themselves. Okay, go ahead, Belinda.
So the answer here would be no. Because this is an administrative proceeding before the licensing board, this would be excluded under exclusion 9 of the trial defense services. So we would again offer him a referral under the preferred member discount, but this is not something, we get a lot of, unfortunately, a lot of calls like Syed's situation, but when you're going before a licensing board, that is not considered a covered civil action under the trial defense services.
That would be any professional that holds a license, right, Belinda?
Correct. Doctor, nurse, attorney,
Okay, Adam sues his neighbor, Ming Lee, at the local magistrate for $2,000. Ming Lee files a countersuit against Adam for $4,000. Adam contacts his provider firm for a referral under his trial defense services. Can Adam receive trial defense services?
And the answer here is no. Under exclusion 10, a counterclaim is not covered when the covered person initiated the lawsuit. So he initiated the action before the magistrate. He won't qualify for trial defense services in defending the counterclaim filed in the same action. But we would, of course, offer the preferred member discount.
Gil is an executor of his mother's estate. The estate has been sued by a medical provider for unpaid services provided to his mother. Gil contacts his provider firm seeking assistance under his trial defense services. Can Gil receive trial defense services in this matter?
The answer here would be no as well. Exclusion 11 excludes any matter where a covered person is acting on behalf of or representing another party. Since this matter involves Gil acting as the executor of his mother's estate, it would be excluded.
Okay. Keisha is a Pennsylvania member who owns a timeshare in Florida. I want to be Keisha's friend.
Yes.
The management company for the Timeshare Association has filed a lawsuit against her in Florida for unpaid association fees. Keisha has proof that she has paid these fees. She contacts her provider firm in Pennsylvania for assistance under the trial defense services. Can Keisha receive trial defense services?
The answer here is absolutely yes. The fact that the civil action has been filed against Keisha in a state other than her state of residence will not preclude her from receiving or qualifying for trial defense services.
Marcus just became a new father and decided to sell his prized 1968 Corvette to help pay for his new bundle of joy. He sold the vehicle as is to Randy. Randy has now sued Marcus for the amount he paid for the Corvette, claiming Marcus sold him a lemon. Marcus contacts his provider firm for assistance. Can Marcus receive trial defense services?
And the answer here is yes. This was a sale of a personal vehicle. He had a valid legal defense. Therefore, he will be entitled to trial defense services. Even though it was a sale of a vehicle, that doesn't mean that he qualifies as a business or a used car sale, that type of situation. This was a personal vehicle, so those exclusions would not apply to Marcus.
Olivia purchased a watch from a retailer with her credit card. The watch was found to be defective, so she returned the watch under the retailer's return policy. But the retailer refused to give her a refund and insisted she take store credit and choose another watch. She successfully disputed the charge with her credit card company. However, the retailer has now filed suit against her for the value of the watch. Can Olivia receive a referral under the trial defense services?
And the answer here is absolutely. She'll be able to receive the trial defense services. She followed the return procedures and should have been issued her refund. She therefore has a valid defense to this action that was filed against her. So we would extend trial defense services in this case.
All right, that ends our slideshow. Now we can take some questions. I'm going to stop sharing here for a second.